Hi, Steve Hansen with Hansen IP Law. One question we get a lot from trademark clients is whether they should register both the words in their trademark and the graphical elements, or what we call the stylized version of their trademark. It's often the case that a company will use words in their trademark, but the words will also have some particular appearance to them. And the Trademark Office distinguishes two kinds of marks. There's a word mark that protects the words, and then there's a stylized mark that protects the words and the way that they appear. And the question is, should a client try to register both? The answer is generally yes. In particular, you want to try to register both if the stylized version of the mark creates a commercial impression that's separate and apart from the words themselves. All right, so why would you want to do that? Well, let's take Coca-Cola as an example. Coca-Cola has a registration for their word mark, Coca-Cola, and they also have a registration or a number of registrations for stylized version of the mark, where it appears with a particular font and cursive and has some extra graphical elements around it. Now, why would you want to register both? Well, because you want to keep competitors from using confusingly similar words, like Coca-Cola with a K, for example, and you want to keep your competitors from using the graphical appearance of the stylization, even if they don't use similar words, because people might confuse that. I mean, you could imagine a scenario where somebody takes that basic Coca-Cola cursive and swirl design and uses completely different words. Still might create some confusion in the minds of consumers because the appearance of those words, the stylization, has become identified with Coca-Cola, and you don't want people to go around using that mark and creating confusion. So in general, you want to do that. Now, the other thing about registering the stylized mark is that so if the words are descriptive of the product or the goods and services, the Trademark Office generally won't register it until you can prove that those words have acquired distinctiveness in the minds of consumers. In other words, until you can show that the consumers recognize the words as an indicator of the source of the goods and services and not just a description of the product. What's nice about a stylized mark is that the graphical elements can sometimes help you avoid that descriptiveness refusal, because the graphic elements aren't describing the product typically. But again, here the issue is, do those graphical elements create a commercial impression separate and apart from the words themselves? And if they do, then that can help you avoid a descriptiveness refusal. So generally speaking, you do want to try to register both your word mark and your stylized version of the mark. A case where you wouldn't want to is really where you just take the words and put them in a known font. That won't really create a commercial impression separate and apart from the words themselves. But if you have the words and you have some pictorial elements surrounding them or something like that, that's a situation where the graphic elements very likely create a commercial impression separate and apart from the words themselves, and in which you would want to protect both the word mark and the stylized version of the mark. Okay? So that's it for now. Until next time, I'm Steve Hansen.